And now,
Hetta.
All right, thank you so much. So yeah, thank you very much for the introduction. And so yeah, I am Karolina Babicka from the International Commission of Jurists, which is a global human rights organization, and we are really excited to be part of this great project managed by Validity, and we are very happy to be on board also with a number of really experienced partners in this field. And so our role in the project is to draft this model disability benchbook. So I would like to here present a little bit where we are, what are our considerations for drafting the benchbook, which should be as practical and as useful as possible. So I think it would be also really great if we then can have discussion and kind of share also everyone's thoughts on the presented draft. That would be really helpful. So I mean, just to say, the benchbook that the ICJ is working on is a model benchbook that will be really rooted in international human rights law and international human rights standards. And it will then be actually further used by national partners to develop national benchbooks that will be adapted to national jurisdictions. So it should be, like, as I said, a practice-oriented guidance and standards on access to procedural rights for defendants with intellectual and or psychosocial disabilities to ensure their equal treatment and participation. And so the main target group of this benchbook will be judges, prosecutors, lawyers, and other relevant professionals in the justice system. And I mean, and we have heard this already in the previous presentations, there are a lot of barriers that persons with disabilities face when they're supposed to be accessing justice on an equal basis with others. So there's a lot of restrictions already, and actually a lot of it has been identified in the national papers that were just presented before the break. So there's a lot of barriers when it comes to physical access to justice facilities, to courts, to police stations, lack of accessible transportations, for instance, but also obstacles in accessing legal assistance and representation, lack of access to information in accessible formats, but also sometimes negative or perhaps paternalistic attitudes towards persons with disabilities, questioning their abilities to participate during all the phases of the proceedings, and also lack of training of professionals working in the field. So a lot of this has been identified, as I said, in the papers. There's actually a lot of good recommendations from national partners to be taken forward that are directed at legislative changes, which of course is a little challenging because the model benchbook will be based in international legal standards, but we may have to recognize that sometimes the international standards give different protection or perhaps better protection to the rights of the persons with disabilities than what is the situation at national level. So that, I think, is also one challenge that we may have with the benchbook. And of course, the need to address training of professionals at all levels of the proceedings or in the administration of justice, I think, is a key recommendation as well we've seen. So, you know, even though the benchbook can be a very useful tool, without that being used actively and probably accompanied then with further training, its impact may be also limited. So I'm just flagging it here in the beginning that this is something we do acknowledge, and that's something that has to be then taken forward. But so the key issues we will try to focus on based on this assessment would be accessibility, procedural and reasonable accommodations, access to information, access to a lawyer and the other procedural rights and safeguards, the right to participate, and we try to focus also on intermediaries or facilitators that also are not there in law or in practice in a lot of countries so far. So just as I mentioned, so the main sources that the model disability benchbook will be using are international human rights standards. So of course, the general international law standards from the International Covenant on Civil and Political Rights, International Covenant on Economic, Social and Cultural Rights, the European Convention on Human Rights, but then of course, very importantly, the Convention on the Rights of Persons with Disabilities and its general comments and case law, which give a lot of guidance already and interpretation of the standards that are contained in the convention. EU law, to some extent, as it does not provide maybe as detailed and specific guidance until now. And one international document just to highlight here are the international principles and guidelines on access to justice for persons with disabilities that we also will be using. So here, and I think there's no need to repeat, just probably to set the framework here, but here are a couple of the main key provisions, standards from the Convention on the Rights of Persons with Disabilities that of course are the basis for the benchbook, and general comments that also then provide this authoritative guidance on the content of the convention further. So far we have drafted a very basic structure of the benchbook, but we're at the stage where we really have to think of how to make the practical part of the benchbook most useful and practical for the practitioners that will be using that. But so that we will have like a disability glossary, and we will have a section on the rights of persons with disabilities, international legal framework, which will basically be putting in a nutshell what I mentioned in the previous slide. So really looking at what are the international legal standards up to date. So also it could be some kind of a reference point where when looking at the actual benchbook, the last part of the document, one could actually go back to the previous section perhaps and see a little bit more the details, what are exactly the wording of international standards articles or what general comments say, etc., etc. And then so for the access to justice section, which is the actual benchbook, so far we have identified a number of chapters that are crucial to be covered, from equal treatment, legal capacity, right to participation, right to information, access to a lawyer, right to interpretation, access to facilities and services, like right to an effective remedy, then rights applicable specifically in criminal proceedings, such as presumption of innocence or procedural rights related to detention. And then we have a section on procedural accommodations and going more into details of that. And as the last section, the need for training for professionals. So I'll just try to go through some of the key issues or key concepts. So this, again, is probably not new to all of you. The Article 5 of the Convention on the Rights of Persons with Disabilities that basically obliges states to take concrete, specific measures to achieve de facto equality of persons with disabilities. So to ensure that they can, in fact, enjoy all human rights and in an equal way with others. I think probably a crucial element to address in the benchbook or explain is the substituted versus supported decision-making, because the substituted decision-making is something that's still being applied a lot in many countries' legal systems, and it actually deprives the person with disability of the right to make decisions for themselves. Instead, it's delegating that right to somebody else. For instance, that can be a formal process that would appoint a guardian for that person, or maybe through some more informal means. But basically, substituted decision-making is in direct violation of the Convention of the Rights of Persons with Disabilities, and it really violates the autonomy and legal capacity of persons with disabilities. While, on the other hand, supported decision-making is a model that requires that people are provided a range of support options, including through the persons they can trust, and it will basically support them in taking decisions for themselves. And so this is really what is requested under the CRPD, and this is where we should be striving for with all the support or accommodations or things that basically we try to implement in the proceedings to support the defendants with disabilities. So procedural accommodations are embedded in the Article 13 of the Convention of the Rights of Persons with Disabilities that obliges states to ensure effective access to justice on an equal basis with others, including through the provision of procedural and age-appropriate accommodation. So these are basically all necessary modifications or adjustments in the context of access to justice to allow or to ensure the participation of persons with disabilities on an equal basis with others. There was, for instance, a case in front of the CRPD where a violation of Article 13 was found by the committee because the person was not able to participate in the proceedings. They were not allowed to testify, to refute evidence, to attend hearings. And the committee specifically said that the fact that there was no guarantee of procedural accommodations in this case, it led to a violation of the convention. And so procedural accommodations can have different, can be various things. These can be procedural adjustments, but also modifications of the environment, for instance. It can be communication support. This can be an appointment of an intermediary or a facilitator or a communication specialist that actually help the person in the proceeding. But they can also help, the whole process. So they can also just suggest, for instance, which procedural accommodations should be taken in place in a specific case. And as Ian has mentioned, there are already such accommodations maybe more often used for other groups of people. So a good example is children. We probably are already used to a situation where in justice proceedings a lot of adaptations have to be made when there are child defendants, for instance. There is adaptation of a language that has to be made. The proceedings should be, for instance, made less formal or less intimidating. The adaptation of length of proceedings is sometimes needed in certain frequent breaks, and of course, every time depending on the age and the individual situation of the child. And that, of course, is basically the same also for persons with disabilities, because everybody will have a different kind of disability. Everybody also will experience it differently, and there is no one fits for all solution, but there always will have to be a need to actually seek the best solution, the best accommodations for the person with disability to fit their situation. There are also these are actually then reasonable accommodations that are then always put into place in a particular case. So these are accommodations that are exactly applied in a particular situation and in a particular context. And there is again an obligation put through the CRPD to suggest them. So the procedural accommodations will often have more systemic character, because that it also just means that these are in place. There is a range of options in place, while the reasonable accommodation will be usually specific to the individual case. When it comes to accessibility, just to say it's of course clear that there must be access to facilities and services to ensure equal access to justice without discrimination for persons with disabilities. So there's already the need of this ex ante duty. So basically, states have the obligation actually when they build a court building, for instance, to make sure that it will be accessible to persons with disabilities, for instance. So this is something, of course, that again we cannot go as far in disability bench book in recommend, but we can recommend, of course, specific accessibility measures. But there's of course also a broader systemic consideration there. I think I mentioned already about intermediaries and facilitators that are used in some systems successfully. There is always a need for high quality training for them. And as I mentioned, there's always individualized support needed. So sometimes some intermediaries will be expert in one specific disability, and that's how they also will be suitable to support a person in a particular case, but they may not be suitable for another one. So this, I think, here even more than elsewhere, training will be really crucial. Like having a range of experts who can be appointed or asked to interfere as intermediaries or facilitators would be crucial. Then I just mentioned here for communication support some examples that we have from the international principles. So these are also some of the suggestions we can be putting in the disability bench book. But again, that would have to, of course, be always assessed individually. And equally for right to information, there's a list of potential ways of ensuring there is access to information in an accessible way for persons with disabilities. So I think that this is just a couple of, or a snapshot of some of the things that we're considering including. And I just thought maybe it would be interesting to include some of the points for discussion. I mean, one question that came up in the previous discussions was the identification of disability, and I think it was also mentioned previously in the discussion today. How to actually make sure that disability is identified at an early stage. Sometimes it happens, sometimes it's discretionary that we've seen in many countries. Sometimes it's only in order to establish insanity defense. So there was actually this question or suggestion, what is the idea about how the idea of universal assessment process would seem to the practitioners. So I think that would be pretty interesting to explore. And then, of course, another question there is who is making the request for procedural accommodations, who decides, and at which stage of the proceedings. And I think that also leads to the third question we had. That was actually a suggestion by Ion when we discussed about the bench book recently, that we could also look at the specific procedural safeguards, then always check what are the issues, where those appear, in which stage of the procedure, and then what would be the practical solution. So this is actually one suggestion that we discussed on how to actually structure the practical part of the bench book. So basically having already a discussion on this or having an opinion from the practitioners in the room would be really beneficial. So I hope I didn't take too much time, and thank you very much for your attention.
Hey, good afternoon, everyone. I am Hetta Pukki from Finland, and I represent the European Council of Autistic People, which is an umbrella organization that connects NGOs and other organizations from around Europe specifically ones where autistic people are in the majority and as primary decision makers. We currently have 24 member organizations in 16 countries. We advocate for people considered to have psychosocial disabilities with a focus on autism, but many among our target groups having several diagnoses. And we are delighted to have the opportunity to contribute for our part to the projects of the Validity Foundations, as we, in our work, constantly witness the negative effects of the lack of access to justice among our members. Both as victims of crime and as defendants, autistic people face situations and tasks in which we have very specific difficulties. They tie in with the definitions of autism. When we seek help or we try to convince others about our side of a story or any description of events, we should engage in social interaction with unfamiliar people. We should expose ourselves to the gaze of people who will assess our credibility by the differences in our facial expression, in our voice and gesture. And we tend to have very long experience of being misperceived and misinterpreted. So it's a very difficult emotional situation to be there. And often we tend not to even try, but to take the path of least resistance and to try to maintain our mental health and our ability to manage the most basic daily functions by giving up on seeking support or justice. We cannot offer a simple description of how to support an autistic defendant. In our experience, the needs of people on the autism spectrum vary so much from one individual to the other that an individualized approach is always necessary. If there are some universal recommendations that we could make, they would probably start with mapping the person's background and existing support system in every case as early as possible. Which ties in very much with things we've heard today. This should start when the justice system becomes aware of a diagnosis or becomes aware of the possible need for a diagnosis. We see that access to diagnosis also varies hugely between different countries, between different parts of Europe, and complicated by the reality that there are large parts of Europe where the existence of autistic adults is actually denied, and people who may have received a diagnosis as children can lose it when they turn 18 and be given another incorrect and inappropriate diagnosis. Hearing what's been said today, a few questions have come to mind. From our perspective, I wonder if this bench book and similar materials could also contain the instructions for the system to contact the NGOs to discuss with the organizations that represent disabled people when they find themselves out of their depth and needing instruction. I would need to ask, who can be the expert who provides help? Is it always the formally trained expert, or could our expertise by experience also contribute, and could it be part of the training that is given to the professionals in the system? There are some details that I would also like to bring up, like for example with communication, when it's mentioned that people need the right to interpretation. This is something that we faced in Finland when discussing some legislation and when engaging with a project that actually had very similar goals. When you say there has to be right to interpretation, it tends to focus on a very narrow section of people, because there is a huge range of communication issues that require help other than interpretation that is just as vital to that person. And in our work, autistic people working and making decisions together, we face this with each other. That we need to begin to understand what each of us separately needs in order to communicate. We have situational mutism, often officially called selective mutism, which already misleads people because it's not a choice. Some may need to type some of the time. Some have unreliable speech, and I'm one of those. Sometimes I need to communicate by typing, not speaking. Some may just be very slow. It may take an enormous amount of time to get that real communication out to that person. My question is, will the system actually bend? It will bend to give that interpretation if it's written down, but will it give hours and hours to someone who needs it? Will it be accepted that someone can only communicate with one familiar person at a time? No. Will it be accepted someone needs to check their text 5 times to actually say what they mean? There are many other things like reliability of interpretation. This is where there are big questions, as in, are all interpretation methods and all interpreters actually reliable? And what checks should be in place? There's a history of decades of debate on certain methods concerning autism and intellectual disabilities. And having observed some situations up close and recently in the lives of people that I know and that my friends know, and people becoming involved in trying to help someone in the criminal justice system, I kind of need to ask, where will we find the clear instructions for what to do when we see that something is beyond reasonable, that something is absolutely cruel? Where are the rights then when we feel that people in the system are actually committing crimes themselves while, not believing the supporters of someone? And we find that the autistic person kind of taken into the system is often utterly isolated from the people who could provide the information and communication support. And the system just says, we can handle it from there. And we're sitting there thinking, no, you really cannot. No, please let us in, not in trying to somehow excuse the person, not trying to say, there should be no consequences, but just trying to say this person relies on help, daily, official and unofficial, every day of their lives. It has to continue. I know of recent situations where someone has actually, been in danger of their lives, being denied the usual, medical devices and medicines while detained. So we need means to intervene. And I hope that this aspect could also somehow become part of the materials that are developed. Now, how are we doing for time? One final thing, reasonable accommodation comes up. I think in this one, it really is a crucial question to define, who then determines what is reasonable? Who has the right to determine that? And this, from our perspective, that disabled person may be in absolutely no position or in no shape to negotiate. So their support system, that exists for them from outside, it is crucial for them to be allowed to be involved.
Thank you, Carolina, for the presentation, and Hetta to such an important sharing. Thanks, Hetta, for sharing your experience and professional insights. So I would like to ask now, Hetta or Carolina, do you have any ideas regarding including the people from the hall in the audience, or should we proceed to the discussion, to questions and answers? Okay, we will do now questions and answers session. Okay, since these guidelines of criminal justice specialists, they are being developed, perhaps there could be someone from remote participants or from live audience. Maybe you have some proposals or some remarks. So what should appear in that material? What could be important for it to be there? Here we heard lots of speeches, talks about disabled people and their rights. But, however, during my short life, I encountered in criminal cases into the procedure comes a person who cannot be held responsible or liable for his or her actions, meaning disabled person. And today I wanted to hear how can we distinguish to avoid making an error in the court. I have to say a few things. Few people I saved during my short life, I saved them from imprisonment. They were recognized as not unfit for trial, spent some time in psychiatry ward in Rokiškis town, and were released. The investigator says there is no documents that he ever turned to some doctor. I say, a person can be born stupid and die stupid, but in this particular case, please be kind and appoint. I have no documents. I will not go into detail here. So please give question or commentary. So I submitted the documents to the investigator with very unwillingly accepted them. Then I went to the prosecutor and she appointed that person who, for heavy crimes, was sentenced twice by the court. This was the first time for him. Third, robbery, incinerating cars, F1 grenade use, Russian splinter grenade, hand grenade. So he was detained holding such a grenade. It could have ended in tragedy. So this boy was taken to experts, and on the next day, they tell, come pick him up. He is unfit for trial. It seems to me that here, of course, it's a matter for lawyers, solicitors to defend a person, so to speak, but speaking about all this, the first thing, a conversation should be held with the judges and with pre-trial investigation officers, because due to their ignorance, due to their hastiness, a big incorrigible errors could happen. And because here I heard a theory. Theory is okay, but I wanted to ask today's speakers who spoke, who presented about what they did, do they in practice? Have you ever experienced a human being in your practice? I would like to speak in person with such lecturer. Okay, thank you. Thank you for your one more moment. Never be in a hurry, because we talk about people's fate, about people's destiny, and I would also like to, for the Ministry of Justice, to initiate so that in our criminal code would be included, amendment would be made to this criminal code, so that in cases of all heavy crimes, forensic psychiatric expertise should be appointed. Okay, thank you. So the question perhaps is most relevant about this practical and theoretical level. Maybe some of you would like to comment on it. How do we implement standards of human rights? What changes should happen in the system? What practical cases were up? There's some distance, right? And how can we react to it? Anyone would like to comment on this aspect?
Maybe I can talk a little bit. Hello, everyone. My name is Bruno Monteiro. I work at Validity Foundation. I have the pleasure of being colleagues with Jan, who presented earlier about different standards on access to justice. And actually, the question and commentary, it's really especially relevant for us when deciding the next steps of the project and the kind of guidance that needs to be developed, right? Because here you heard throughout the different presentations, different standards, different things that needs to be done. And when it comes to the matter of assessment of persons with disabilities in criminal proceedings, then what we found both in this project and this has been our experience so far is these kind of assessments on capacity. They tend to be used to exclude the person from the proceedings themselves. What these kind of assessments are missing and tend to miss is, as also Hetta was pointing out, is the need to actually understand the person themselves. What is that person's background? What is that person's situation? Does that person have support of a family? Does the person have support of a lawyer that can help understand the case, understand the proceedings about what's happening? In practice, the experience for persons with disabilities tend to be very disempowering. They come to the courts, they receive different commands, instructions on how to behave, what to do, and there's very little information shared about what they can do, and the information that is available, as pointed out by Gabriela also earlier, as findings in Lithuania, that information tends to be very complex. And so what's important as a way forward is how to create these more inclusive processes so that persons with disabilities are in a better position to actually to provide evidence themselves, to actually ask questions, to intervene, and also feel more positive about the outcome of the case itself. Here, when it comes to actually practical recommendations, it's something that that we'd like to explore more as part of this project and in the future, is the role of intermediaries in the criminal justice system. Because in different countries in the UK, and I believe in Spain as well, if our colleague Natalia from Plena Inclusión might like to pitch in, we do have a role of a specialized professional that works for the justice system, and the particular role of this person is just to facilitate communication between the person with disability and different professionals in the justice system, to guarantee that there's common understanding about, on the one hand, the person's situation, and also for the court to be able to execute the functions that they're meant to do so. And what we found in the project, but here I think I would like to encourage Natalia to come in to share a bit of her experience in Spain about how this kind of experts actually have a very beneficial role on how defendants can actually participate in the criminal justice system, especially whenever there's communication barriers. Natalia, would you like to come in?
It's okay. Well, in this case, facilitators, what they do is analyze and work with the person to see what are the barriers on the communication in comprehensive that they have. And with all the information and the meeting with the persons, like this, what they do is make an inform, and they say what they need to adapt in the process so they can fully participate in the process, not only in the criminal process but also in the civil process. So that's what we are working on Spain. We are also developing now a training for different facilitators in Spain with a university called UNED. And we are doing this in collaboration with lawyers, public prosecutors, with also national police, civil guard, local police. Well, it's kind of new, but I think we are going to have really good outcomes of that.
Ačiū labai, Bruno, ačiū labai. Kolegiai, dar yra klausimas ar reakcija.
Yeah, one more question or comment. Thanks. I will speak Lithuanian, if I may, even though I want to address the representative from Spain. When you talk about these facilitators, do you develop the practice that these facilitators could only help the defendants or also victims? Because the European Commission comes up with a proposal to review the directive of victims' rights. And in this directive, well, a new provision is to provide, well, assistance to the victims of crimes during the, criminal, let's say, procedure, both defendants and victims. Or are you talking only about the defendants? Because both defendants and victims, if they have disability, they can be vulnerable. Thank you.
Oh, yes. In our case in Spain, we talk about facilitators every time there is a person with disabilities in a proceedment. It doesn't have to be victims or defendant exclusively, but every time we have a person with disabilities, there could be that necessitate facilitators. They can intervene. It's not only for defendants.
Well, it seems to be that we're at the very end of our discussion, interesting as it is, and I firmly believe that this discussion could be followed up and we could have informal discussions. So I can only rejoice at the fact that we had about 250 participants today from at least eight European countries. So that's something, and our guests, our partners, our colleagues, well, are really grateful to all of you for your contribution, for your sharing your insights, for your commitment, for your dedication to this noble cause. And now I would like to give the floor to, sorry, not to give the floor, I would like to invite all of us to join hands, not to lose ourselves, because we are talking about transdisciplinary things. We have many stakeholders if we want to find the best possible answers. And this meaning the inclusion of persons with disability into, inclusion is important. So our consortium will come up with a bench book, and we are not at a standstill, and we are going to present this information in the near future. And also I think we have to organize specialized training. So the organizations participating in this consortium will be responsible for them. Let's say mental health perspectives will use a Facebook account to make this information public. And of course, there are different ways also possible of providing information, of communicating, but a technical thing is very important. I want to ask all of you, all the participants, to fill in the evaluation form. It's the request of the European Commission, and you will receive this evaluation form, and be so kind, fill it in. We'll have a recording of this event online, and as I said, mental health organizations, our NGO, will make the information available on Facebook account. And once again, many heartfelt thanks to all of you. It's a short meeting, but I think it was very rich. It was information was abundant, and we have to do what we can to actually ensure that human rights are implemented in all the EU member countries and all over the world. Thank you.